I did, and then I canceled it, so make sure it's recording.
Okay, we're recording.
Okay. All right, we'll go ahead and open this hearing. I'll begin by reading the notice of public hearing. Notice is hereby given that the following hearing will be held in the Bonneville County Courthouse, 605 North Capitol Avenue, Idaho Falls, Idaho, July 21st, 2020 at 2 p.m. by the Bonneville County Commissioners for the purpose of public hearing in relation to the application of Rodney and Marlene Shurtliff, trustee for Winkle Investments Limited Liability Corporation, for a rezone from agriculture A1 to residential R2. The general location is the north side of 49th South, located between 25th East and Ammon Road, specifically on the west corner of 49th South and Streeter Avenue at Oak Falls, Idaho. There was a legal description along with instructions how to participate, either in person or on Zoom. And this was published July 5th, 2020 in the Post Register. Those present, Commissioner Reed, Commissioner Christensen, Commissioner Radford via Zoom, and members of the planning and zoning staff. To begin with, we'll have, who's going to present? Steve?
I am going to present today. Steve
Okay.
is
Michelle.
not 100%, so I will present.
Okay.
All right, Michelle Hagan, Assistant Planner with Bonneville County Planning and Zoning. This is a map amendment from A1 to R2. The applicants are Rodney and Marlene Shurtliff, and property is located at 49th East, 49th South, and Streeter Avenue. It consists of 2 platted half-acre lots, which total 1 acre within the suburban acre subdivision. On the screen, we have the land use map, so you can see the property has an urban residential land use in that area that's within the county. The lighter pink color around it is land that is within the city of Ammon jurisdiction. The parcel is adjacent to the city of Ammon, across the street, and you have 81 properties within the county jurisdiction in that area. The county has no residential zoning in the area. It appears to be spot zoning jurisdiction. There are areas within Ammon, they have differing residential zoning districts all around. The applicant, they provided will serve letters from the city of Ammon for water and sewer. And then they've indicated on their application Rocky Mountain Power is in the area. The Planning Commission held a public hearing on June 3rd and recommended denial of the rezone request based on that they thought it was spot zoning and concerns over access for multifamily housing, and they did not see how it could work. Do you have any questions for me?
Not at this point, but by way of instruction, where this was a recommended denial,
Yes.
I forgot to, we've already got the testimony from the Planning Commission, and without objection, we'll make that part of the record. We've already reviewed that, so we have that testimony. So the purpose today is to bring any things that you think they were wrong in their recommendation, or additional information that you didn't have at the time. So with that, any questions?
No, it seemed like it did really revolve around the spot zone. So remind me again, the zoning around this.
So you have suburban acres, which is a subdivision that was platted in the 50s, and it is predominantly 1 acre lots, and it is zoned ag. That is all within the county. And then you have ag zoned land that's also within the county. You have that square, as you can see on the map, that's at the corner that appears to still be in the county, and it is also zoned ag.
But my question, is what I was trying to understand is, it's zoned ag, but it is residential housing, 1 acre lots,
Yes,
right up to it, so.
yes. Well, you can have a home in ag lots.
Yeah, I know, but in this case, we've got a lot of homes, we've got a subdivision.
Yes.
Do you wish, Shurtliffs, I'm assuming?
Yes,
Do
we
you
are.
wish to testify?
Mr. Chairman, I had just one quick question, if I could, before you go to the applicant.
Let's let them give the information first, because that may answer it.
Okay,
Yeah, this is the microphone, so if you just speak loud.
Yeah, close. Yeah, well, you have the minutes from the planning and zoning meeting, I guess, so I won't establish those, but the thing that did confuse me as I pondered this after we left that meeting was it seemed, as you stated, that the reason that our application was rejected was because of spot zoning. And I thought that they focused.
I didn't state that, it was stated in the presentation.
Oh, okay, somebody
I
stated
made
that.
reference to it.
Okay, sorry about that.
Okay.
So anyway, as I thought about that, I thought, okay, spot zoning was never mentioned in the comprehensive plan for Bonneville County that I ever saw, as I read through that plan. But what was covered in that meeting was all of the things that our application did meet relative to the comprehensive plan, Bonneville County comprehensive plan I'm talking about. And one of the things that was in the comprehensive plan, which I don't think was really addressed in that meeting, was major residential areas should not be unduly stereotyped or exclusive. A mixture of housing types should be, well, the way it says, the proposal should permit flexibility in residential site design and a mixture of housing types. Established multifamily residential areas should be located functionally convenient to a major street. Anyway, there's a whole item, a whole bunch of things that were included in my narrative that I submitted that it seems to me were not really addressed by the commission. And yet, I would think that would be those would be important aspects if the application, as it's stated, really wants you to address how it affects the Bonneville, how it fits in with the Bonneville County plan. And if you look at all that, the plan, other than spot zoning, it fits right in and meets the plan's objectives as I read it. So spot zoning is subject to interpretation as I see it. And the Commissioner Ward in that planning and zoning meeting indicated that if I were to contact some of the neighbors in that area and see if they would be willing to go R2, then that would have an impact. And so I thought about that and I thought, okay, so if I were to get one neighbor adding one plat, of the subdivision into the request, that would have an impact. How does that really change the whole idea of spot zoning? So I'm here to ask, so what's your definition of spot zoning? How big does it have to be? We've got 2 half-acre lots. How many half-acre lots, or how many 1 acre lots, or how many lots really have to be included in order to say, okay, we no longer have the criteria of spot zoning? That's confusing to me. Quite frankly, that property has been there unoccupied since 1959. So it's pretty obvious that nobody wants to build a residence on 49th South on that location. Otherwise, they would have bought those properties and done it. And when you look at it, location-wise, close to commercial properties, close to main, the hit road, all of that that's going in on just a few hundred feet to the west, it's an ideal location, ideal application of that property, in my opinion, for multi. So
I'd like to have Steve address the questions of spot zoning, because it's more ordinance and statute than it is opinion. But my first question, you're adjacent to the city of Ammon. Have you talked to Ammon about annexing? Because in the comprehensive plan, our impact area agreement encourages those who are adjacent to cities.
And that, I have mentioned that to them. I haven't pursued it. They've indicated the procedure to go through to do that. I would prefer to be in the county for reasons and so forth, but that would be an alternative that we've looked at.
Steve, are you on here? Oh, we can't hear you, Steve.
Sorry, there we go. Basically, the definition on spot zoning are defined by court actions within the state. There's several parameters they look at. In general, the issue that they deal with is a property owned by a single property owner. Are they small tracts? Are they not associated with an adjacent use? In this case, even within the city of Ammon, the zoning that they have doesn't address multifamily zoning. The agricultural zone that we have surrounding is also, it's all ag zone, even though they do have platted 1 acre lots on it. It's still not designated as residential on the plan. So it's still identified as an ag use. So normally the case falls apart on whether it is dissimilar to all adjacent zoning. If there is no similar zoning adjacent to it, even if it's a larger tract of land, it can still be considered a spot zone. So they don't define it on a minimum acreage size in the case law. It's always refined to adjacency and compatibility with all of the existing zoning and uses surrounding the property. So that would be a determination that the commissioners would have to make a decision on, as to whether you feel that it complies or not with the general definitions of spot zoning. Typically though, in this instance, where we don't have any similar zoning, it's fairly ripe to be considered a spot zone.
Commissioner Radford, you had a question?
Yeah, I guess I didn't understand the services that were mentioned. I apologize, I haven't read the hearing notes about it. Maybe this question was asked, but if they're that close to the city limits of Ammon, what does the applicant in terms of sewer and water, what's his thoughts there?
They mentioned in the presentation that they had a will serve letter from Ammon.
Okay, thanks.
Does that answer
Yeah.
your question?
Yep.
Mr. Shurtliff, does that answer your question?
Yeah, it sounds like it's just up to the discretion of
It is.
the commission.
We just wanted it all on the record on those sites. So do you have anything else to add?
I don't believe so.
Mr. Chairman, I've got a question for Steve in regards, I don't know if you want to do it now or do it later.
It's a technical question.
It's in regards to what he just talked about.
Yeah, if you have clarification, yeah.
Steve?
Yes.
So help me understand that a little bit more then, because I'm still a little confused where that property near it was developed into 1 acre housing lots. Am I correct? Years ago. It's still in A1, but today that would be a residential zoning. We wouldn't allow all those lots to be put there under an A1, so.
We do have similar situations currently in the county where we have residential units that are still zoned A1. The one I would show you as a response is the ag density subdivision plats, where we have transferred all the division rights to a corner of the property where we might have 10 or 12 lots. And they would still put all the homes on it, but they're still zoned agriculture. Compacting them and putting them into a density zone, or adjusting them and putting them into a corner where you adjust the lot sizes down, doesn't mandate or change the land use zoning, the land use or the zoning of the property. It can still be agriculturally zoned and agriculture on the comprehensive plan. They're just using their division rights. When this particular subdivision was done, I'd have to look at the exact date on it. It might have been, if it was before October of '59 when it was recorded, it was actually then have been platted and laid out before the zoning ordinance was in place. And as such, then the commissioners at the time simply did an overall judgment call on what the zoning they felt needed to be when they passed the original zoning ordinance. And I think that is the situation on this plat.
Yeah, and that's what I wanted to say. This isn't just putting the density in a corner. I mean, this is a lot of homes. I don't know how many homes are there. It appears there's quite a few. I didn't count them. But this is a different situation than just grouping the division rights in a corner. Correct?
Yes.
Or am I?
It is different other than the concept of having the zoning with a multiple number of housing units on it doesn't necessarily change the land use designation.
The date on the Suburban Acres creation was June of 1959.
See, then that was done before the subdivision ordinance or the county zoning ordinance was adopted.
Okay, but the current status of the zone is still agriculture, and what we're talking about is changing the zone to a C2, correct?
No, R2.
R2, D2. Okay. Any other questions? Any other comments?
I don't believe so.
Member of the public wish to speak?
I don't know, the other thing they had concern about was the,
State your name
oh, I'm
also.
sorry, I'm Marlene Shurtliff.
Can you state your address as well, please?
3425 April Drive in Idaho Falls. The only other thing that they were concerned about was the road, because it's two lots, it had an access onto 49, but we don't have to, we easily can make it so it only access onto Streeter. So if that was a concern, that's not a problem. That can be remedied. So that's the only thing I wanted to mention.
So I did have a question on that.
Okay.
Lance, I see you're on in the meeting with us, I believe. I saw you earlier. That was one of the other questions I had, because I saw that was troubling the road and bridge. Would that satisfy the problem if they only had an access onto Streeter?
If they only have an access on a Streeter, it solves most of the concern that I had. There's still going to be quite a bit of traffic on Streeter, and they don't have very much frontage on Streeter to get access out. So it will create a conflict point at the intersection of Streeter and 49th South.
So would you elaborate a little bit more? Would road and bridge allow that or not?
I think Road and Bridge could work with it. All I'm saying is there's going to be a concern, and there's less of a concern if they only exit onto Streeter than if they were to try to propose an exit onto the arterial road.
Okay.
Okay.
Because the disadvantage of leaving that as two separate lots and building one house on is then you have to get onto Streeter. I mean onto 49. Although there would just be one house, but you still have to, it would have to go out there on that one lot. And where with what we're doing, we could take it all off onto Streeter.
Well, you're talking about one lot for one house, and what you're proposing to do is a fourplex or an eightplex or something like that, where multiple cars would access it every day. There's a distinct difference in my mind about the number of vehicles involved.
There would be a difference in the number of vehicles, but I think what she is saying that if it is considered only for residents, single family dwelling, then you have to have access on the 49 South from the second lot. So that means, and John told us that Road and Bridge said that would be okay. We wouldn't even have to apply for that. If
For a
that-
single family dwelling,
Yes.
we could work with it. What you're
Yeah.
proposing is not a single family dwelling.
No, I agree, but I'm just saying that with multifamily dwellings, surely you would have to go out on the streeter, but you are the last property on to the corner. I mean, you are the corner property. So you're not, it's not like you're interfering with traffic to speak of coming from through, like you don't have to drive through the subdivision to get out. You know, you're right, the last property on the corner.
I understand that. It's just the amount of vehicles entering onto Streeter and stopping at Streeter without adequate stacking length on Streeter.
Well, the stacking length would be into the complex.
Okay, thank you.
Okay, with no other members of the public here for this, we'll close this hearing to public comment. We'll take the issue under advisement. Steve's here. We'll put together some proposed findings. We'll get together and discuss those. We can come to an agreement. We'll do that. That'll be held in a public meeting, but not a public hearing. We can only take the information that's been put on the record to do that. I'm guessing that'll be probably 2 to 4 weeks. And then we normally do those on Wednesdays. If you want to watch, they're posted on our regular. We try to do those around the road and bridge. So thank you. Quick break. Okay.
How are you?
Good, how you doing?
Good. Did you sign in?
I did.
Thank you.
What's the next one?
Is Rockwell Homes rezone.
Wear that shirt, we're not gonna have a football season. Don't let you try. I know. They're just afraid to play BYU. Okay, about ready?
Yeah, I never did stop the recording. so-
Okay. So you heard the BYU comment?
Yeah, it's on the record.
Okay. Okay, we'll open this hearing. I'll begin by reading the notice of public hearing. Notice hereby given that the following hearing will be held in the Bonneville County Courthouse, 605 North Capitol Avenue, Idaho Falls, Idaho. July 21st, 2020 at 2:15 p.m. by the Bonneville County Commissioners for the purpose of public hearing in relation to the application of Rockwell Homes Inc. for rezone from agriculture A1 to residential R1. The general location is the northeast corner of 41st E North and 45th East, Crowley Road, Idaho Falls, Idaho. This was published along with the instructions how to participate both in person and by Zoom, July 5th, 2020. To begin with, we'll have Michelle Hagan go ahead and present the application. For the record, we do have the transcripts from the planning and zoning hearing and all the exhibits, and without objection, we'll make those part of this record. So go ahead.
Thank you. Michelle Hagan, Assistant Planner with Bonneville County Planning and Zoning. So we have a zoning map amendment from A1 to R1 from Rockwell Homes Incorporated, represented by Kurt Rowland of Eagle Rock Engineering. The applicants have also submitted a master plan preliminary plat named Hatch Hollow. The property is located on the west side of North 45th East, Crowley Road, and north of 41st North. It's a little over 68 acres, and it's located east of an existing canal and west of Crowley Road. It's currently the property is currently being used as farmland, and the area around the canal and west of it, along with the original home site, has been retained by the original property owner. The land use designation is urban residential, as you can see on the map. And the property is within the area of impact with the city of Iona. You have subdivisions adjacent to the property. Can you switch slides? So you have the Sierra Springs and Southwick and Little Sand Creek Forest Estates, and then Berkeley Park subdivision is to the south, and then you have the Brown subdivision across on the southeast corner of 41st and Crowley. The Planning Commission held a public hearing on June 24th, and they recommended approval of the rezoning request. Do you have any questions?
Not at this point.
Okay.
You? No. Okay, to begin with, we'll have the owner or the representative, any information they want or they think is relevant.
Kurt Rowland with Eagle Rock Engineering, 1331 Fremont Avenue, Idaho Falls, representing for Rockwell Homes for Hatch Hollow, 68 acres approximately, and we are requesting rezone of R1. As was said, we took it to the P&Z Commission and they recommended approval to go forward to the commissioners. We're going to put in approximately all single family homes, about the same size as Berkeley Park. We spoke with engineering department, Road and Bridge, and Lance had us reconfigure some of the roads that we, on the original plat that we turned in. And we also have some wording in the development agreement that we're going to put in some, bury the bridge on Crowley Road, and there's a bridge that needs to be widened on Hatch Lane.
21st North.
Bury the canal, sorry. Did I say bridge? I'm sorry.
I was confused.
Bury the canal on Crowley.
Okay.
And we also have another bridge that we have to put in Berkeley 8. Is that correct, Lance? Berkeley 8?
Yeah, I think so. Yeah, it's Berkeley Park 8. But that's crossing down below. You'll have to fix the bridge up at basically the
Yes.
west end of this too.
Yep, up there on Hatch Lane.
Okay, that's what it's
41st North, not Hatch Lane.
I've lived here all my life. I can't get used to road numbers yet.
Well, I grew up there in the tax line, so I know what you're talking about. Okay, so that does include that improvement.
Yes.
I remember when we had to fix that bridge.
Yep. Yeah, it's in the development agreement.
Okay. Any questions? Dave?
No.
I have one question.
Yeah.
So in the property purchase from the Hatches, was there any discussion about access onto 41st North?
Into the property they retained, that they kept?
Yes, because Alvin Hatch has asked to meet with me this afternoon, and I suspect he's going to ask about that.
Yeah, we changed our master plan for the property to the north, where we have the school planned. But we have that main road coming from, is that Tower Road? What's the name of that road? To the very north?
49th North, I think, is an
Yeah.
Yes, 49.
49th North. Anyway,
I'm talking about 41st North.
yeah, we're gonna take a road from 49th though, go straight down into Hatch's property. And we also have, down there by the bridge, there'll be an access into his property also.
I'm talking about the remainder parcel that's adjacent to 45th East.
The farmhouse?
Yes.
Sorry, I thought you were talking about the piece west of Little Sand Creek.
No.
That he kept. Yes, he'll have an access off of 41st. It'd be just basically a driveway access, if that's okay with the road and bridge.
Well, that's what I wanted to check and see if there was discussions when that land was purchased from the Hatches about what was promised versus what was not.
As far as I know, between Rockwell Homes and Hatches, I'm not sure what was agreed upon right there. But I'm assuming since they purchased the rest of the property, they would provide him an access into his.
Well, he already has an access off of 45th East, correct?
Yes, he does.
So that's why I'm asking about an additional access on the 41st North when there is an existing access on the 45th East.
What would you like? What would Road and Bridge like?
Well, I want to be clear if there was something promised by Rockwell. If there was nothing promised, I'll work with Alvin Hatch.
You might want to talk to him about that because I don't know of any agreement that was made there.
Okay.
You'll be able to work on that, Lance, at the planning level and
Yeah.
things like that, because this is just for the rezone.
Yeah.
Yeah.
So, any other questions?
Nope.
Seeing no members of the public here to testify, are there any on Zoom that wish to testify? Hearing none, we'll close this hearing to public comment, take the issue under advisement. Steve will present some proposed findings in the next 2 to 4 weeks. And
Okay.
we'll go from there.
All right.
Okay.
Thank you very much.
Did you want a copy of this map?
No, it's fine. No.
Oh, you looked it up.
Yeah.
That's it for me.
Okay, thanks. Got people, anybody here for the next one?
Yes.
Okay, we going? We're recording. Okay, let's go ahead and begin this public hearing. I'll begin by reading the notice of public hearing. Notice is hereby given that the following hearing will be held in the Bonneville County Courthouse, 605 North Capitol Avenue, Idaho Falls, Idaho, July 21st, 2020 at 2:30 p.m. by the Bonneville County Commissioners, for the purpose of public hearing in relation to the application of Dustin and Jesse Wageman for the appeal of the Planning and Zoning Commission denial regarding an additional division / building right for a parcel in the Grazing G-1 zone. General location is Bone Road, Iona, Idaho, 827 Bonneville County, Idaho. The legal description was published along with instructions how to participate in this hearing, either in person or by Zoom. This was published July 5th, 2020. This is an appeal of the planning and zoning. Was this a variance?
No, it was an appeal. I'll explain it in my presentation.
We've also read all the records, all the transcripts from the planning and zoning hearing, and those, without objection, we'll make those part of the record. So you won't need to repeat a lot of that. This is the opportunity to have heard the information there, to come up with any additional information that you think might be relevant. So we'll go ahead and have Michelle present.
All right, Michelle Hagan, Assistant Planner, Bonneville County Planning and Zoning. So this is an application by Dustin and Jesse Wageman for an appeal of the determination of the Planning and Zoning Commission. The Planning and Zoning held a public hearing on June 3rd, and which they denied the application. The hearing on the 3rd was an appeal the zoning administrator decision regarding division rights and the ability to build a second dwelling on the property, or that there was no division rights available to split and build another home on the property. The minutes are included for your information, along with the transcript of a voicemail from Brent Elkington, and we also have a letter from the Elkingtons. The property is located at 1585 Bone Road in Bone, Idaho. It's 68.51 acres. The surrounding area has an agricultural land use designation, and the property in the surrounding area is zoned grazing. This area has a density of 1 dwelling unit per 60 acres. The next slide, we've got our aerial. Thank you, Austin. Parcel was created in December of 1980 from the original farm with 1 division / building right. The Planning and Zoning Commission denied the appeal based on the fact that they do not have the authority to change the law or grant another building right, and they thought that there may be another option for the property owner. Do you have any questions for me on this one right now?
Well, what I was referring to was them appealing the
Yes.
decision of the planning.
Well, there were 2 appeals,
Okay.
essentially. They appealed on the zoning administrator determination that they couldn't split their property, and they were not allowed to build a second dwelling on the property because our ordinance allows 1 single family residence per parcel of record. And so they weren't able to do that. My understanding, the applicant can explain the reasons behind what they're wanting to do.
Yeah, there was a lot of those reasons in the first hearing.
Yeah.
There may be additional, but the property, the split was in 1980.
Was 80 or 84?
Okay, who originally split the property?
Rockwood or either Rockwood or Hartenson?
Okay, and well, I'll ask, is it Wageman or Wageman?
Wageman.
Wageman.
Yes, sir.
I'll ask Ms. Wageman when she gets here about the purchase dates and things like that. So, any other questions?
No, I don't.
Dave?
I guess, can you hear me okay?
Yeah.
I had a question that maybe Steve Steer could answer this. If this was split previously to at those dates that was mentioned at the hearing. Is that a self-imposed hardship? Is that what I understand from this application?
Have you read the minutes?
Yeah, I just wanted Steve's opinion.
It was pretty clear in the minutes.
The, just to clarify, the property has had several researches done on it. The property, the original property owner, before the Wagemans bought it, they had requested information whether the property could be split. They were notified by letter that the property had no additional division rights. The Wagemans also had access to that information. There were no additional division rights before they purchased the property. And there was a second research letter that was written and also made available to them prior to their purchase of the property, acknowledging the limitations of the property, the use of the property to only one single family dwelling.
Okay, so it's changed hands 2 times and both property owners were notified of the splits being used up by the previous owner.
Yes, they were.
All right, thanks. Thanks, Mr. Chair.
I guess my question is, I couldn't remember which date the Wagmans bought that. It was just within the last 3 or 4 years, wasn't it? Or just recently?
Last August.
Last August, real recently?
Yes.
Okay, that's what I was trying to remember. Okay, any other questions? Okay, Mrs. Wagman? State your name and address. If you can speak real loud, it'll pick you up from there.
Okay, yes, I'm Jesse Wageman. My address is 1585 Bone Road, Iona 83427. We were aware that we, in the very beginning when we purchased the property, could not split. We thought, you know, eventually when my parents were more serious about retiring out here, we could maybe purchase a building right, or there would be ground around us for sale to purchase, you know, just so they could be nearby. And there's not ground for sale, and I don't really foresee there, you know, being much ground close by for sale. And we have reached out to purchase building rights. There are none to purchase. We have a neighbor that wants to trade a building right, but then that would also put a driveway along our property to lead back to more homes, and we just don't want a driveway right beside our house to get to more homes. So we don't want to trade 2 acres for a building right to create more houses behind us and a driveway right beside our home. If we could purchase another building right from a neighbor, we would love to do so. That should not be an option to us. So therefore, and we would love to keep it zoned ag. We are farming it with our neighbors, the Myers. Under rezone, we plan on continuing to farm. We just would like my parents, as they retire, to be nearby, not 30 minutes away in town, but really close by, especially when they get in their older years. So.
And I don't know who would answer this, Steve or Michelle. Who are the neighbors around there? And this is for the Wagmans. You probably know this, but just for the record, who are the neighbors around that they could potentially purchase division rights from that they're adjacent to?
To the, let me keep pulling that up. Okay. We have behind them is, I believe, Hawkins. See the one?
He's the one that would give him an ag easement back to that parcel, that northeast parcel.
Okay.
Because currently he only has ag access to use that on our property, and he wants to own that access. So he can then build back there, because right now he cannot build unless he has a 30-foot easement.
Right, but that's, yeah, those are individual negotiations. I'm just curious which other, there is a, well, maybe they can do it there. There is a pointer on a remote for this
Okay.
TV.
All right, thank you, Austin. So the, you also have, so you have Hawkins to the south, the parcel to the, next to them, directly to the south, they would not have, they are the same situation in that the parcel was created with one building Right. And then you can only transfer division rights to property that is adjacent. So you can go be adjacent to Crossbone Road. The Elkingtons are there. To the north, are you also to the north of them? Your letters, I'm sorry, I'm talking to this Elkington,
He said two sides.
two sides.
I don't know.
Yeah, you're on
Yeah.
both sides.
I don't know about the buildings though.
Okay.
So, and I'm, who's,
So essentially you have the Hawkingtons, or the Hawkins, the Elkingtons, the Rockwoods, and I think that's it.
So does the Rockwoods have a permit though, or you're saying that they?
I don't think they have any division rights remaining other than, one building lot for that. They divided the original farm site, and so each of those building rights went with each of those lots that were created. And Hawkins, and then the Elkingtons. Imagine that, I know you have a lot of land. I haven't researched their property myself, so I don't know how many division rights they would have. I know there's some history there with that, transferring division rights at different. So that's what I know. Steve, do you know of anything else out there?
The parcel that's to the rear probably has 10 division rights. It's roughly 600 acres in size. Stan owns. The two pieces to the north that Stan owns, there could be one possibly on each of those. The Elkingtons, I've not researched theirs, whether they have division rights or not.
Okay. I was just curious for their benefit.
But the tract to the south, there's no additional division rights because these two are split.
That's the ones that you said Rockwood's own still?
Yes.
Originally, there was another Rockwood that had the parcel that Wagemans have now purchased. It was a different Rockwood, but it was family.
I have a question. So I believe there was a letter of support from the Elkingtons
Yes.
for
Sandy's here if you want to.
Okay.
Good question. I'm guessing that's you behind the mask.
I guess I'm just curious if that's been investigated. I don't want to get in the middle of what you're doing here, but that appears to be an option. There are building rights.
I don't know about the building stuff.
Okay.
I mean, we've asked neighbors, and our neighbors are well aware of what we're trying to do, but of course, we're not pushing the subject. So we're trying to fulfill it on our own.
Okay.
Any other questions for Sandy? Do you wish to testify?
I
You've
guess
got your
one
letter.
thing, it's not like.
State your name and address.
Yeah, and can you come forward, because you
You're-
have a softer voice.
Sandra Elkington, 1316 Bone Road. We're not trying to, we don't want to do like, workers sell to have, half acre, a third acre, have houses on every third acre. But I think we're okay with having them, their, 50 acres of grazing and then split off, and so her parents could have a house. Anyway. Thank you.
Thank you.
Sorry, I called you Sandy.
That's okay.
That goes way back.
That's what they call them most of the time.
Okay, any other questions, comments? Anybody online that's zoomed in that wishes to comment? Do we have anybody?
There are some, I think, for the next hearing.
Okay.
Yeah, I think both the ones on it for the next hearing.
Okay, hearing none, we'll go ahead and close this hearing to public comment. I'll take the issue under advisement in 2 to 4 weeks. Steve Williams will discuss those. It'll be a public meeting, but not a public hearing. You're welcome to attend or listen, but we won't be taking any more public comment. Okay,
Thank
thank you.
Thank you.
Work on getting maps brought up.
We're recording.
Okay. I'll begin by reading the notice of public hearing. Notice is hereby given that the following hearing will be held in the Bonneville County Courthouse, 605 North Capitol Avenue, Idaho Falls, Idaho, July 21st, 2020 at 2:45 p.m. by the Bonneville County Commissioners for the purpose of a public hearing in relation to the appeal of the Planning and Zoning Commission approval of Todd and Paula Jacobs variance from the 100-foot parcel width and road frontage requirements to 70 foot in an agriculture A1 zone. The general location is 1021 West, 145 North, Idaho Falls, Idaho, Bonneville County, approximately located along northern county line near Snake River on West 145th North. This had a legal description along with instructions how to participate both in person and by Zoom, and it was published July 5th, 2020. To begin with, we'll have Michelle present this, but first we will, we've already read the transcripts from the minutes from the planning and zoning hearing. Without objection, we'll make those part of the record. You don't need to repeat that. We already have access to that. The purpose here is to add any additional information or arguments for your application. And we'll go with Michelle to start with.
All right, Michelle Hagan, Assistant Planner, Bonneville County. This is an application by Steve Sear, Zoning Administrator, appealing the approval of the variance for Todd and Paula Jacobs. The Jacobs applied for a variance from the 100-foot parcel width and road frontage requirement to 70 feet in an agriculture zone. The Planning and Zoning Commission had lengthy discussion during a public hearing on June 24th over the request, which resulted in a 3-3 vote, with Chairman Beck breaking the tie, resulting in approval of the request. The administrator filed the appeal based on the fact that the board did not address each of the variance criteria, as well as the fact that the parcels were created after the adoption of the zoning ordinance in 1959. The property is located on 145th North, also known as County Line Road, and it is adjacent to a canal, and they are located east of the Snake River. Property has a suburban mixed-use land use designation, and it's zoned agriculture. You have 2 parcels of land. One is 5.287 acres, which became a parcel of record May 5th of 2005. The parcel is developed with an existing single-family home and accessory structures. The second parcel is 17.337 acres and became a parcel of record January 7th of 2008. And this parcel does not have any road frontage, and it is currently being farmed. Parcel does have a building right. However, because it does not have any road frontage on the county road, it's not eligible for the building permit. The property owners, through the variance process, were attempting to reconfigure the 2 parcels in a manner so that way they would each have some road frontage. One would be, and then the other one for the 70 feet. Do you have any questions for me at this time?
Question. Okay. So help me understand why the Planning and Zoning Commission weren't instructed during the time of the hearing to go through each of the limited use requirements.
We did tell them that they needed to address each of the criteria. They went through them, they read each one. However, they didn't address each, they didn't say something after each comment. Sometimes they just read the criteria and then no one said anything. And I did not go back in and reinforce that they needed to have an answer to each of those criteria. So they didn't.
Part of what may clear this up, since this is an appeal from the planning administrator, I was gonna have Steve go ahead and give us the reasons, since he's the appellant,
Okay.
why he appealed.
Okay. Some of the main concerns that we have regarding this application is they have other options in being able to develop the property, which we have addressed on previous properties. One of the most recent was the Rosemarie subdivision on the west side, commissioners might be aware of. They need, if they want to do this property, they're not allowed to create additional frontages on it. They also have a problem in transferring division rights from one parcel to another without filing a subdivision plan. The actual problem that the owners have is they have the ability to file a subdivision plat, dedicate a road into it. They just do not want to have the expense for putting the road in. This is also similar to the one we had at west of Yukon for Deal. They need to put the improvements in for putting the roads in to be able to get the frontage on the property. They have no problem in applying an agricultural density subdivision on this and using those rights. They don't have to rezone it, but they would be responsible for dedicating the road right of way and constructing the road into the property to give it frontage. The way the board addressed this is they felt their justification was that they didn't think that it was required to have that much expense to be able to make it comply. So they just granted them the variance to the reduced frontage. They have, with 70 foot of frontage, they have the ability to put the road in it. They only need 60 foot of road right of way to be able to dedicate the public road. If they extend the road into the back of the front parcels, they don't have to necessarily build the road clear to the end of the agricultural property that they have on the 17-acre piece on the rear. But they would still need to put the road in and put a cul-de-sac on the end of it with the ability to have it extend in the future if they divided the rest of the property.
Question.
Well,
So,
in that fact, the board granted the variance because of the cost justification as opposed to rather than making them comply with the minimum requirements of the zoning ordinance.
isn't there I don't have them in front of me, but aren't one of the issues a unique circumstance, and the road you're talking about crosses the Idaho Canal?
The Idaho Canal was one that was brought up by Lance. That's not the approach that we were discussing. The approach that we're talking about would be if they built the approach right off from 145th, coming down the east side of their property in the same location where it's proposing to put the 70-foot right of way to get back to the rear property. I'm not advocating that they approach and have connection to Jacobs Lane. That particular one is not practical. This one is a practical solution though.
So building across the canal comes out of a subdivision across from the canal, right?
Yeah, they have to build a bridge across the canal, and then Jacobs Lane, I believe is the name of it. It is there, but it has not been constructed. So that's really not a viable approach. You can see on that photo, it's a very wide bridge crossing. If they
70-foot strip, the 70-foot strip that comes in there is wide enough to construct a public road.
Yes, all you need is 60 foot of width. They could put that in and still get the road constructed stay on the east side of the property. And they would only have to build the road to, well, where you have it shown on the photo now, back to the red line at the south end of that property.
Okay.
And this tract is actually being cut out of the front parcel, not the rear parcel. But they could transfer the division rights from the rear parcel onto this one through filing the subdivision plat and constructing the road.
Okay. Any other questions of Steve before we have the owner?
Right now, yeah.
Yeah, let's hear from the owners, and then we may have some more. Who wishes to testify? State your name and address.
Okay, my name is Larry Todd Jacobs. I live at 1021 West, 145 North.
You can sit down.
I'm one of the property owners, my wife and I. There may be, I've got quite a few notes here that I want to go through and kind of in rebuttal, some of it, a lot of it actually, to what Steve has said. And so I'm going to try and follow through this. If there's questions as I'm going, please interrupt me. I'm not very good at this, and I apologize if my bald head is blinding anybody on the screen or here in the room. But so I'm kind of stepping back a little bit on, my son and my wife went in and talked to the Planning and Zoning Administration back in March, maybe end of April or February, excuse me, and to discuss what it would take to obtain a building permit for my son to build. We'll just throw this up right now too. This is 4th generation living on the property. The misconstrued notion that we created our own hardship in the application appeal is that we purchased the first 5 acres, 5 1/4 acres, when my grandmother passed away. And we bought that through the estate.
What date was that?
That was in 2005. That was in March, I believe, of 2005. I don't remember exact date. So this property's been owned by our family since 1942. It was kind of misled during a lot of this that we just kind of bought this property and created our own hardship with the way that we went about purchasing it. And then in 2008, the rest of the farm, which I wish I could have bought, but don't have that kind of money, was sold to Dean Mortimer, and that was when we were able to purchase the other 17 point whatever acres, which was a natural break from the rest of the farm east of the canal, Idaho Canal. So we purchased the remaining property that was on the east side of the canal. And at that time, I had no, my son that's looking to build there was, 11, 12 years old, right in that neighborhood. The thought of somebody building another house there was just not, I knew I had a building division back there because Dean tried to get me to quit claim deed it to him in order to add it to his plat on the other side of the canal. And it was like, no, we'll hold on to that for future. I had no idea that you had to have 100 foot of road frontage at that time. That became known to me with the letter dated March 2nd. And that was when we found out that, again, Michelle already pointed out that the 5 acre one did not have any more divisions, but the 17 acre one did, but minus the road frontage, it wasn't eligible at this current time. So the letter that we got from them, the 2 options that were given to us was to, first option would result in reconfiguring the 2 parcels to allow for both parcels to have required frontage on 145 North. However, the existing structures have to maintain the setbacks. So when we start talking about the 60-foot row right away on the east, now you start to compromise the setbacks of my existing house from that road, from that right of way. Now you start getting into issues of, well, do you say it's grandfathered? Do you say it doesn't matter? What do you do? Because if there's a 60-foot right of way there, my side property and my existing house starts to become where it may not meet those, and probably doesn't meet those requirements for setback. It meets the setback between property line to property line for my son to me, but the setback from a county road, it starts to become another issue there.
Well, instead of letting these add up, let's ask Steve or Michelle what, to clarify what the setback situation would be with 60-foot road.
All right, so within the A1 zone, you have, when it's unplatted subdivision, if it's just a regular meets and bounds lot, you have, it's 55 feet from the right of way for a road, or 80 feet from the center line of the property. Now, if you have a platted subdivision, your front yard setback is 30 feet in ag. Let me just double check that to make sure I'm remembering that. Yes, it's 30 feet for a platted lot from the edge of the right of way.
Okay, where are the existing buildings that this would impact?
Okay.
See the right up there in the tree, there's a tree that covers some of the house there. Right, that's where my house is current.
What's the distance from the property line?
It's about 30 feet
To the back of the house.
from the proposed property line.
Well, from the proposed 60-foot.
It would be the 30 feet plus about maybe 10 feet. So roughly 40 feet to the side yard there.
And what was the setback requirement? Would that meet the setback requirement?
If they did a subdivision plat, which they would need to do for a road, it would be 30 feet, would be your corner side. You would have your front yard being from the county road, and then you'd have a corner side from that other, so it would be 30 feet for both of them. So they have a reduced setback from that, so it, otherwise, if they reconfigured, they would have a 20-foot side yard setback.
Okay, but the simple answer is if they platted that and made the road, it would meet the
I
setback.
think they could make that.
Okay, that's what I-
So may I make a comment on the platting and the road and everything? So the road to get a county, and that's another thing that's a little difficult to find out, what's a county standard road that has to be built. So I called an engineering company, Ellsworth Engineering. They referred me to just go straight to H&K, and I was quoted $190,000 to build that road to the county standard in the 60-foot row. And so then when you get the other part about the subdivision, you're going to have that same 190,000 plus whatever other cost it is to do the subdivision, which is in the paperwork says fire suppression systems, different things. And in the end, my desire is not to subdivide this land. It's just to build a single dwelling, reconfigure the property. And later on, I'll give examples throughout just really close local where there's parcels all over out there that don't meet the 100-foot requirement. And I'll get to that later on here. And then of course, when they presented the building the bridge, that was just way out of line. First of all, Jacobs Lane and that plat across the canal has never been followed through. The road's never been developed. I would have to get property from or at least from one, that there's no land for sale to start with, to build a road, to build a bridge across to the other side. I don't even know where the numbers add up to that. But in my opinion, that's part of the variance, and looking at what the ordinance going through that is part of the hardship of this. It can be hardship is financial also. And that's my opinion anyway. So is there any more questions on what I've had to say so far? One other thing I need to add there is, other than when we went in, we decided to go the variance route because it is something that's allowed per the ordinance to go in and request for a variance. And so we followed through with that. And that was the only request that we were looking for, was the 70 feet in lieu of the 100 foot. Due to the layout of mostly structures, if we tried to cut 100 feet, I've got a lot of frontage across the road there, but as you can see, buildings and structures and things that are there, if I cut 100 feet out of the middle, then I would end up probably having to create 3 parcels out of this, with my house being separate. I'd have to kind of make a U shape through there. I could maybe make it so it worked but I'd still need to reconfigure the properties to give the 100 foot row, right, or the 100 foot on the frontage. You have to look at the future too. What if the kids were to have to move, leave, sell a house? I don't really think that's feasible to have a property going right through my yard. And even though my kids, I'd love them to death, I would just soon have they have their own access also to build their house. So again, we had the hearing on the 24th of June. The variance was passed by the committee. After the meeting was over, Steve continued. They didn't record it, wasn't a record afterwards, but there was some discussion that he was not happy with the committee for passing this variance, and that he indicated at that time that he would more than likely appeal it. I talked to Michelle on the 25th and the 26th, and he hadn't done anything at that point as far as appealing it. I asked at that time if maybe Steve could come out and actually look at the property, and I asked Michelle this, not Steve, and it was indicated to me that he was not in a position to do that due to the virus, the coronavirus and the pandemic stuff going on, because he has a family member that's high risk, and I fully understand that. But it would have been nice to be able to point out it's hard to just look at these properties on maps and not go look at them. But I understand that wasn't possible. When I got a hold of Michelle on the 6th of July to find out that's when I found out that Steve had in fact filed an appeal, and she indicated me that she was still working on the wording of the appeal and would email it to me. And at that time, I asked about the 10-day window to file an appeal and have it filed, because that's what the ordinance indicates, is that you have 10 days to file a written appeal. On the 6th, which is 12 days in, it sounded like there was an appeal filed. On the 2nd is what was indicated to me, but there was no written portion available at that time. So I asked the question, is this even a valid appeal if it hasn't been filed within the 10-day window, written and filed? And that discussion just kind of ended there. But when I was emailed on the 13th is the first information I got. This is the paper that I got, and it's never been received as far as the planning and zoning. I don't know what the protocol is for this, but to me it indicates that it potentially was never filed within the 10-day window to do the appeal. And as of yesterday was the first day that I actually got the meeting minutes. So to me, it was being massaged along the way since the hearing. That's the way it appears to me. If I would have been filing the appeal, on the other hand, mine would have had to been in the office, written and done in the 10-day window. I don't feel that happened here. Again, that's my opinion. Now we'll go back to As far as on the appeal, the Planning and Zoning Commission, they did read through the criteria. And if you look at the minutes, which are part of the record, he asked for comments, questions as he read through. This would be Chairman Beck. Upon finishing that, he said that there'd be a roll call vote because it was very tight. And it passed. So here we are today. I wanted to just reiterate a couple of things off of his appeal, which, number one,
Mr. Chairman,
sorry, go ahead.
I keep wondering if we should resolve the issue of the appeal was filed in time, because this whole process might be mute for.
Well, I don't know if we can resolve it, but we'll have Steve put on the record what he did, and then we'll review it.
Okay.
Because that is it's a legitimate point.
It's pretty serious point to me.
I just didn't know if we want to go through the whole hearing without resolving that.
Probably, just because that would be part. We have heard Steve's timeline and the explanation.
I'm sorry to interrupt.
Oh, no. I kind of just rolling on here, and then anybody interrupt me that needs to. And obviously, this means quite a bit to me. And so section 1-511, item 2, Planning and Zoning Commission may grant variances from the strict letter of the ordinance where property owner can show that by reason of peculiar topographical features or other special circumstances peculiar to the particular lot or parcel of land, the strict application of the terms of this ordinance would prohibit the use of the applicant's property in a manner reasonably similar to other lots in the same zone. So now we'll go to doesn't take long to search. Property on 665 West, 129 North. There is a road that was never deeded to the county. This one's actually come up before with an individual that I know. They wanted to build a house over here, and they were told no because that road frontage on 129 North going east of 5th West was never deeded to the county, and there is a dwelling there. So in effect, no frontage to the property. Road was not deeded to the county. 11275 North, 5th West. That property has no road frontage. It is off of 5th West. 1281 North, 5th West, not deeded as a road, not improved. It's got 28 feet of frontage out here. Here's one on 113 North. There's about 20 feet of frontage, and so there's no 100-foot requirement to the setback on that piece. I've got about 20 of these total. Do we want to keep going through them?
I'd like to submit those and make them part of the record, and then they'll have a chance to.
Okay, that would be, because I don't want to bore everybody with going through this whole stack here. One of the unique things that I find.
Chairman, I had a question of Todd, if I could.
Yeah, Dave.
I guess my question was on those 20 properties that you mentioned, you cited the ordinance for variance citing if it was similar. Are those all within a mile or 2 miles of your property?
So they're all, well, I'm on 145 and I went out to about 81st because from there I don't know what becomes subdivisions and what doesn't. So with about 3 or 4 miles of my property, Dave.
All of them? All of them are within 3 or 4 miles?
From Willow Creek in out to county line, so I got to think Coltman, Fairview, Willow Creek, or Coltman, Yukon, Fairview, Willow Creek, so about 4 miles to the south of me. Some are on and then there's some examples on the North River Road or what I call West River Road. But they're all in the same zone is what I was looking at, the same A1.
No, but the relevant question on
That answers my question. I had one other question, Todd, while I have you, goodness, Chairman. Do you feel like when you went through the variance process that you were helped by the county planning and zoning to do such? I mean, it seems like that's a pretty tough bar to jump through. And it sounds like you went through all the steps to file a proper variance request. And did you feel like you got help from the planning and zoning at the county to do that?
Michelle was the only help that we got from the planning and zoning office.
Okay, at this point, that's probably irrelevant, Dave. I mean, the variance was filed.
But
we can drag it on through a lot, but the thing I'm going to point out on those is we need to have them look at them because you indicate not deeded to the county, but there are a lot of roads that are prescriptive.
yeah, well, and then there's some interesting ones in here in the tail end of this
I'd like to see it.
that show that actually on 81st North, there's about 6 or 7 properties in a row, and they're in the end of this that actually somebody else owns 50 feet from the right from the road back to these property. He's not even one of the property owners, so it must have been a plat, maybe something, and maybe that's why I'm seeing some irregularities there.
Did you look these up on our county website?
I did.
Okay, did you notice there's?
I did. I did.
That's what we need to look at.
Yeah, and I appreciate that, Roger. I'm just saying that from a.
We can keep this thing.
Yep,
moving.
that's why I don't want to keep going through those. In the end, I will say though, to Dave's comment that I did not know what I was really getting into when I came into the variance as far as what was expected of me. I probably walked into that ill-prepared. That's why I came a little more guns loaded today.
That's the purpose of the next hearing. You can
So-
prepare yourself.
So I and I appreciate everybody's comments, I guess you'd say, whether they were good in my favor or otherwise during the hearing, because it helps you understand a different perspective, I guess I'd say, because I look at it from, hey man, in my closing here, I'd just like to say this is a 14. We're just trying to get a fourth generation family there. Excuse me. This has no effect on anybody else whatsoever. If we build a house there, it doesn't impact public safety. There would be plenty of access for any emergency vehicles that would be maintained by the owners, us. I do understand the need for ordinances and county rules because I'm right across the road from Jefferson County. And believe me, there's a lot of stuff goes on over there that I wouldn't like to see in our county. It's pretty much a free for all. I've got neighbors right across the road and there's probably 25 dogs in 2 yards there, roughly. So there's things that are good. Again, I want to go back to the cost. The gravel road, very expensive. The subdivide, I don't want a subdivision. I don't know what the plat thing, that was never really explained, other than it's another big process that I really didn't understand to go through. Almost looks like you need to be a developer to start getting into a lot of these other things. So I felt like that was as good a hardship as anything. And the one more comment that was in the appeal was that the planning and zoning acted beyond their powers per section 1-5117 of the ordinance by their approval of the variance. Well, I totally disagree with that because section 7 flat out says that The Planning and Zoning Commission will express administrative authority as set forth in this ordinance and shall have the power to perform those acts as are herein set forth, and such administrative action shall not be interpreted as unauthorized amendments to the ordinance. And so you go back to section 2 and 3, and that's exactly what the variance hearing was, and that's exactly what we went through.
And could I make a request? This is the only copy you have of all this information.
Yeah.
Could you give that to Michelle? We could make copies of it and then return the originals or copies.
Oh, absolutely.
Because we want that to be good.
You even want my hand scratching?
I would. Along with the marked up copies. Now to get back to the, I think we've got enough information on the variance part of it. Let's talk about the deadline. So Steve.
Mr. Chairman, you'll have to straight up. I can't, Mr. Chairman.
Okay, Steve, we're talking to the point where we're going to talk about deadlines. We need to have Steve on that.
All right, your sound is really breaking up on the panel, so. The issue is a 10-day time frame, which we've implemented and utilized all the time. You do have a 10-day time period to be able to file an application or an appeal of an application. If the 10-day time frame occurs on a weekend, it is extended to the 5 o'clock on the following Monday. We grant that to everybody on all applications. We have done for 40 years that I'm aware of. Because
go through the dates with us then.
If the hearing, the planning boards typically are held on a Wednesday, and if
Okay,
you
give me the dates.
24th of June.
24th of June. And that's when they issued their decision. So the first day would be the 25th of June.
If you add 10 days onto that, that puts it on into the weekend. And we cannot deny, we never have denied the applications to be extended to until 5 o'clock on the following Monday.
And what date was the following Monday?
I don't have the calendar in front of me.
6th of July.
What's the date on it?
The date that he signed the appeal was the 2nd, but so it should have been completed by the 2nd. But then on the appeal paperwork, it also has a line that says received by, and it's blank. And by the way, since we're in the ordinance and Steve seems to be a rules guy, there's nothing in here that says the following Monday. It says written appeal 10 days.
I think that's an administrative rule statewide, but let's see, I had a question because there's something in there that said we'll have a written appeal.
Yes.
Okay, Steve, do you want to explain why there's information? Did we have a written appeal or just a notice?
I cannot, I'm sorry, Commissioner.
What?
Can't hear you.
Would you address the issue that he brought up that said we have to have a written appeal within 10 days? And he indicated that he didn't, you just notified him that you'd made an appeal, but no written part outlining the appeal.
It was written, it was included in the application and submitted. I had signed the application beforehand. Michelle was working on the final verbiage because I was not in the office. I was isolated. But it was,
when the wording was given when?
it was completed and everything was included on it when it was submitted on that Monday.
I'm sorry, but I could not get a copy of it. And every time I called in, I didn't get a copy until the 13th. Michelle indicated that she was still working on the verbiage on the 6th and that I would have a copy of it by end of business on the 6th. I did not receive it until the 13th.
Is that accurate, Michelle?
I know I had emailed it. I don't know how it didn't get through to him. I know I emailed it to him. And then I think you gave me a different email when I talked to you.
I gave you an additional one, yes.
And so that is the one I have also used.
So what we'll probably need also for the record is your email that you sent out to him on that day.
All right.
Okay.
Do that.
That'll help us clear that up.
Yeah. So one of the things though is that the part of the written appeal was the meeting minutes.
Does it say that in there?
It does. It says in the appeal, it says the minutes will be attached along with the documents that were provided. Those were not even completed till yesterday. That's right here on the appeal paperwork.
And you want to address that?
I know that we get the minutes transcribed as quickly as we can. We've had Suzanne has had an accident. She has been the one who's traditionally done the minutes. And so she was not able to get them done over the last week, but we would not have had a chance. We didn't have a chance to transcribe the minutes prior to that 10-day hearing. My understanding is that we don't necessarily have those done in time for all appeals. The Wagmans was the same in that we didn't have them done when she had filed her appeal of the Planning and Zoning Commission.
Okay, read, so I don't have to come down there and do it. Read, says the appeal with the minutes.
Okay, I'll just read this paragraph of the appeal. The P&Z did address some of the criteria. However, they did not comment on each of the applicable criteria, being A through E, that were necessary criteria. F for personal hardship is not applicable to this application. Then it says they also failed to recognize that the lots were created by the property owners in their current configuration, therefore they created their own hardship, which that was what I disputed earlier. I don't feel that I created my own hardship because I did not create the land to start with. The existing lots were created by the applicant in 2005 and 2008 in their current configuration.
Okay,
What I'll skip to now is the Planning and Zoning Commission received a copy of the staff report and the applications by the Jacobs with their narrative. The Planning and Zoning acted beyond their powers per section 1-511.7 on their ordinance by the approval of the variance. The minutes will be attached along with all documents that were provided to the P&Z, and that's right on the application here. So to me, he said that that's part of the written appeal.
A little different than I understood the word in the beginning, but Steve, could you clarify that?
Does the application, what we are indicating that when it was submitted, we're going to get to the commissioners, you'll have the detail of the minutes so that you can do the review when you reviewed the appeal application. The appeal I did off from memory of what took place during the meeting because, again, we do not always have the transcripts, everything completed. It takes time to get the transcripts done. So the appeal application was based on the notes that we had during the meeting, and we were indicating that we were going to attach the minutes so they were available for the commissioners for review before the hearing was processed.
Okay, which you did attach the minutes to the commissioners, but not, you didn't get them to the Jacobs till
Yesterday.
Okay, but I thought early on you made it sound like it was in our ordinance that we had to provide.
There is right here is and it's highlighted, sir, but right here in the appeal, there's a section 1-512 that indicates that it has to be in writing within 10 days.
Okay,
And it doesn't indicate any leeway into the weekends.
and that's, well.
But that's, if,
We'll get legal counsel.
yeah.
to-
No, I'm just,
But,
I've drugged that one on plenty long enough. I just want you guys to understand how I kind of feel about it. think I've been clear.
Well, I had one question along that line, Mr. Chair, if I could have, about the application itself. When you received it, there was no date on it. And I guess I have a question of Steve. Do we normally put a date on it when we send it out? I thought we did. There was a blank for it. Why was that blank that the applicant, to defend himself, wasn't dated? I guess that's what I want to know.
The date is something that the office typically puts on it when the appeals are received. I can't tell you why they didn't put the date on it. I can just tell you that I know that it was submitted on that Monday, was processed, and Michelle had it in her hand on Monday afternoon.
But she didn't date it.
Did not date it. No, but I know the receipt was there. It was received.
Okay.
Okay, I think we've got enough to noodle through. Anything anybody else wants to ask?
Well, I've got one more question to fully understand, Steve. Why the Planning and Zoning Commission didn't receive better instructions that night to go through every point? I don't feel like the applicant should be penalized because of the lack of process for them. I mean, we had staff there that could have made sure that all the I's were dotted, the T's crossed.
Well, the correction statements, if you go through the minutes, there was the majority of the board members who were voicing opinions as to whether it was going to be approved or not. Normally, we don't try to interject comments into them in the administrative process unless it becomes obvious. We did not know that it was going to be a tied vote. It appeared to be, to begin with, that it was going to be 4-2. After the motion was passed, there's no way of going back and correcting the process.
So what I heard there, personally heard there, is that they didn't expect this to pass, and when it did, then hindsight was, oh, wait a minute, now I got to do something.
Okay. All right.
Thanks.
I think we've got enough on the record. Yeah,
Thank you.
and we've addressed those in the proposed finding. I'm looking a little different direction than that on the dates.
You'll need to speak up, Mr. Chair.
Okay. You got any other questions?
Well, I guess the only other question I have of Steve, because the chairman of our Planning and Zoning Commission, he's just a volunteer, but he cast the deciding vote in favor of the applicant of the variance. He's not a newbie. He understands the process. In my opinion, he's been through quite a few land use planning issues. I think he served on the Planning and Zoning Commission at least 8 years. Do you feel like that Chairman Beck didn't understand his vote, Steve, or do you think he fully understood his vote?
I can't address that comment.
Yeah, that's trying to get inside somebody's mind. I think what Commissioner Reed is talking about is making sure that the applicant, not the commission members, understand. Is that correct?
That's correct.
Yeah, and if it's a little hard to hear that, we apologize, but that was the reason for Commissioner Reed's question. Okay, with that, if there's no further questions or comments, we'll close this hearing.
Public needs to
Oh,
open it for public input. There's
I
people
figured
on
they were
Zoom
family
or
party applicants.
anyone else.
So,
I'm Nate Jacobs. I live at 1452 North, 600 East in Shelley. And I'm Nate Jacobs. I'm Todd's son. I just wanted to give you guys a little insight into why we were even going through this process. We started this variance 5 months ago, and we just keep fighting through the process because this piece of property means the world to my family. We don't really want to destroy the integrity of the farm. We still want to keep, we want to have a pasture. We want to But farm's been my family since the 40s. My dad was raised on the property, helping his grandpa on the farm. I was raised on the farm, and it's been a dream of mine to raise my own family on this property. It'd be a 4th generation with my son. It'd be 5 generations growing up on that property. And I just want to thank you guys for your time to listen to this. So that's it. Thank you.
For your comments. Okay, anybody else? Okay. Like in marriages, speak now or forever. Right? So, okay, we'll call this hearing to a close. We'll take the issue under,
The river lots are on,
oh, okay.
so I
I
don't
keep
know if
forgetting the
they want
Zoom.
to
Is there
say anything.
anybody online that wishes to comment? I think the regular lots make testimony in the planning commission. I saw that, so we'll take that into account also.
Wanted to make sure they had an opportunity.
And I appreciate you pointing that out. Okay, with that, we'll close this hearing to public comment. We'll take the issue under advisement, 2 to 4 weeks. And have a nice day.
Hey, thanks so much.
Thank you.
Hey, thanks, you guys.
Thank
you.
Oh, did you want that? I need to make the copies. Oh,
Yeah,
We'll get everything here.
okay.